This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutzke is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutzke.
And we are now joined by Todd Lutzke from the law firm of Cushing & Dolan. The segment's called Ask Todd because it's your chance to ask Todd your questions. So we're going to open up the studio line at 888-205-2263. That is the number to call to ask Todd a question about your estate plan right now. Again, it's 888-205-2263. Todd, how are you today?
I am never better, and you?
I'm struggling a little bit.
Uh-oh.
I'm locked out of my computer. I'm trying to change the password on it to beef stew.
To beef stew.
The computer keeps telling me that it's not quite stroganoff.
That's good. I like that.
So I'm working on it, but we'll
come up with a new one.
I digress. Let's talk a little bit about the idea of stepped up cost basis and how it relates to estate planning. First, for anyone who's not familiar with it, what is stepped up cost basis and how does it work?
So a step up in cost basis is when you die owning an asset. Even if it's in an irrevocable trust that was an incomplete gift, because remember, you might not have given away something. If you die owning an asset that's included in your estate, and then it passes through the estate to somebody, like to you, Chuck. So if I died and you inherited my home.
You left your home to me?
I know. I'm nice like that. I'm the giver. And so if that happens and I paid $100,000 for my home 40 years ago and today it's worth $800,000, the gain on that would be $700,000, the difference between 8 and 1. If I give it to you during life and you take it and you go to sell it, you have to pay the tax on the gain of $700,000 because I gave you my cost basis when I gave you the asset.
So if you voluntarily gift an asset to someone, they are sticking with your original cost basis at that point.
If it's given during life, correct.
Yeah.
Correct. However, if you die owning it, which is what we're talking about, then you would get that same $800,000 asset. You would get a cost basis equal to fair market value on the date of death. Wow. What does that mean? If it's worth $800,000 and you inherit it because I died, it's as if you paid $800,000 for it. So if you go to sell it, your gain would be 800 minus 800 or 0, and we saved all the tax on that built-in gain.
So let's say that you are someone who you have a significant estate and you are trying, for a variety of reasons, you're trying to either get assets out of your estate, you just want to make gifts to your children or grandchildren so that they can enjoy your money or assets while they're still alive. How do you balance the desire to make those gifts with the capital gains considerations?
And that's just one of the things we need to think about when you're thinking about gifting, which is exactly why we're doing this guide this month, right? So the answer is don't just gift because you get that warm, fuzzy feeling, Chuck, like you're talking about, right? Oh, it feels really good if I make the gift. And I get it. It does. But you know what? If I don't need to make it, maybe I shouldn't. Example, if I'm going to give away assets that are highly appreciated, like the ones we just talked about, you then need to say, well, what is the built-in capital gains tax that I've given to my children versus the estate tax savings I hope to gain by making the gift? And it's really, when you say, how do you do it? Pick your poison. You really need to balance that and say, well, if I'm under $12 million, I'm saving nothing by making the gift on federal estate taxes because it's not taxable anyway. If I'm at $3 million and I can shelter $2 million here in Massachusetts from state death tax, well, what's the tax on $100,000 or on $1 million in Massachusetts? Well, it's about 30 or 40 grand. Well, you know what? I might be having much higher capital gains tax on the asset I gave away Therefore, I'm not making that gift.
Sure.
It really comes down to thinking about those issues. And that's just tax considerations. You have other considerations to think about, from control, creditor protection, even how it affects Medicaid. People don't realize there's a Medicaid implications associated with gifting. It's unbelievable how many things you have to think about before you do something that's kind.
Talking with Todd Lutzke from the law firm of Cushing & Dolan. If you have a question for Todd, this is your chance to ask it to him. The number here for the studio is 888-205-2263. So get calling that number if you want to ask Todd Lutzke a question. Right after this next break, we're going to go to your questions with Todd. That number again is 888-205-2263. One last time, it's 888-205-2263. Let's take a quick break here, and then it's right to your questions with Todd after this.
Todd Lutzke answers your questions about estate and elder life planning every Wednesday at 10:30, right here on the Financial Exchange Radio Network.
All right, we're going right to your calls with Todd Lutzke from Cushing & Dolan. Let's kick things off with Philip in Harwich. You're on with Todd Lutzke.
Hi, Todd. I'm a client of yours, and 4 years ago you put a trust together for us, and you said it's a 5-year look back. But I forgot to ask you 4 years ago, do I have to come back after the 5-year ending to take another look back as to how it's going with the trust?
So
that's what I'm not sure about.
Yeah, so it's a great question for anyone who's done planning, really, whether it's with me or with anyone else. The answer is the quick answer is no. You don't need to come back and say, oh, I made it through the 5 years. I love to hear the story. It's wonderful, and congratulations that you make it through the 5 years. So I'm always excited to hear it, but there's no legal reason for you to come back in. That said, I will tell you and everybody else who's listening that, sometimes you want to call, not necessarily because it's been 5 years and I got past the look-back period, but maybe if something has changed dramatically in your life, then, yeah, you might want to come back. And those issues might be, I got divorced, oh, that would be a reason. Or I lost a spouse, that would be a reason. Or, maybe my assets have just grown significantly in value and I want to make sure that the tax laws haven't changed in a way that caused me to maybe modify my plan in some way. But, short of those things, likely your plan is very well, still doing very well the way it is, and staying the course is fine. And the only other thing you might think about is if there's a lot of assets you haven't put in the trust and you're now more comfortable with the trust and you wanted to, start a new 5-year waiting period, you could, but only for the new asset you put in. You could always add a little bit more to the trust. So I hope that at least helps you and really everybody else who's done this kind of planning. And, one thing I want to mention about this kind of planning that is very different than what people think about, and it really brings me to the guide, which is to gift or not to gift and the tax implications. When I tell people to make a gift, I want them to gift generally to an irrevocable trust, not to a child, just because it's, you can protect it from their creditors, their divorces, save it for the next generation. It's just way better than an outright gift. But I also want people to understand that some irrevocable trusts are incomplete gifts, like with this Medicaid trust that Philip was calling on. Even though we put all those assets in there, we did not make the gift. And that's because we wanted to preserve the step up in basis that we were talking about with Chuck earlier on. Folks, when you make gifts, just remember there's all kinds of things to think about. Not only tax issues, but when you make gifts, even though you don't pay a gift tax, you are creating a 5-year waiting period for Medicaid eligibility. You might not think about that when you're making the gift, but you need to. So think about it, learn, get the guide. What's the best way to make a gift or not to gift? 866-848-5699 or go to LegalExchangeShow.com. You can download the guide there. Again, 866-848-5699 or LegalExchangeShow.com.
Todd, we've got another caller lined up for you. Let's go over to Andrew in New Hampshire. Andrew, what's your question for Todd Lutzke?
Hey, guys. Thanks for taking my call. So I have a partner that I own a house with. We're long-time relationship, but we're not married. And she has a daughter, college age, and we're trying to figure out if we're going to leave the house as an asset. We're both on the title for the house. How does that work as far as, let's say, in the event of a death, for instance?
Yeah. So here's a real. This is a lot of people are like you, Andrew. Either they're just never got married, or later in life spouses have died, and new people have got they've got together in their own, and they have existing children from existing marriages, and they just never got married. Well, there's pros and cons to that, right? So if in your case, if you want to leave that house ultimately to that daughter, to her daughter, owning it jointly works great if you die. If you die, it goes to her. Hopefully she would then take care of her daughter, and that's probably the case. It's not a great estate planning idea, but it would work. However, if she dies first and you get the house, she needs to know that you can do anything you want with it. I'm not saying you wouldn't take care of this person. Maybe you're very close and you feel like she's your daughter, and you would, but you don't have to. And not to mention the fact that you could give it to whoever you wanted to. You could remarry and move and then end up giving it to a new wife. And more importantly, you could just live your life, get sick, go to the nursing home, and the nursing home takes it. So there's so many things to think about here that probably this joint ownership arrangement, to me, leaves way too much at risk. Too many what-ifs in the plan for my comfort. If I was you and things are going well, you hate to ruin a good relationship by getting married. I get it. But, marriage might work here. That way you can set up a trust and plan for each other as to where the house goes, protect it from the nursing home, avoid probate, eliminate a lot of those what-ifs by getting married. And if you don't get married, maybe still set up a trust as two single people to try and control this a little bit more. But again, not being married might make it a little harder. So I think there's lots to think about.
Got another one for you, Todd. Let's go over to Clara in Wilbraham. Clara, you're on with Todd Lutzke.
Hi, good morning. Thank you for taking my call.
Morning.
My parents bought a rental property back in the 1980s for probably around $60,000, and last year they put it in a life estate with their kids' names on it. How's that going to affect the tax liability?
Yeah, so this is really a big problem, folks. Many people, you're not alone in this, Clara. There's so many people who use life estates incorrectly. So what they did, folks, is they transferred the home, saying like, I, Todd Lutzke, give the property to my two children and retain a life estate. That's what they did. Well, first of all, it's not their home. It's a rental property. So if it's not their home, arguably the life estate is not really helpful. It's not even protecting it from the nursing home, because a life estate has a value to it, and the only reason it works with a primary residence is because the primary residence is not countable. So if you have a life estate piece and you get sick and go in the nursing home 5 years after you create one of these, then it would be protected. This one wouldn't even be protected. Secondly, at least it would provide a step up in basis when they pass, and it would ultimately go to you kids. And you would at least not have a huge capital gains tax problem. But right now, the other issue you have with this, and again, this is a completed gift. Again, back to the guide, right? This is a completed gift. Probably they weren't even thinking they were making a completed gift when they set up the life estate, but they were. So be careful here, because now if something happens to any of you kids while they're living, this is really your asset. Not to mention the fact that if there's a slip and fall, they're going to sue not only the life tenant, they're going to sue the future owner as well, which is you kids. So there's liability risks there. So folks, don't just make a gift incorrectly. I'd get this fixed. Maybe check it out. Get the guide. That's really what we're trying to tell you, is how to gift to not make these kinds of problems.
Todd Lutzke, thanks for joining us today.
Always a pleasure.
The views expressed in this segment are solely those of Cushing and Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing and Armstrong do not endorse each other and are not affiliated. This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutzke has been presented by Cushing and Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com.